Welcome to Albion Chambers' most recent updating video on financial remedies. Alex West and I are going to talk about pensions and arbitration respectively. Alex is going to talk about pensions, particularly as in these Covid-19 times. I'm going to talk about arbitration and the renewed interest in it as a form of dispute resolution in lockdown times and thereafter. But first of all, I want to introduce you to Alex. I'm sure he is well known to many of you. Alex is a member of the Matrimonial Finance team within Chambers, and he undertakes the full range of financial remedy work, from the modest value needs-based cases to the larger sharing cases with a significant asset base. He's been practicing now on the Western Circuit for over 6 years, prior to which he was working in London for a financial services firm and also a Magic Circle law firm. Here is Alex, and here is his talk on pensions. So Alex, we're going to deal with this as a question and answer session. And the first question I really want to ask you is whether, in the Covid-19 crisis, has that affected pensions on divorce? So if I had a case coming in for trial now, and I'd received my pension report in, say, February of this year, can I still use that for a hearing in, say, July or August?
Well, Deborah, firstly, thank you for that introduction. I think this question is a question that all of us are asking at the moment, and it's a question which we don't have a huge amount of certainty on. As ever, the answer is going to depend on the facts of any particular case, but in the interests of keeping things short and to the point and giving us all something to work with, I think there are two key questions to ask. Firstly, what are the types of pension that I'm dealing with? And secondly, what is their significance to the case as a whole? And I think when looking at the different types of pensions, the following general rules are useful to bear in mind. Firstly, if the pension is a defined contribution scheme, its cash equivalent value is likely to have gone down as a result of falls in the stock market. Secondly, if the pension is a private sector defined benefit scheme, then conversely, its cash equivalent value is likely to have gone up. And thirdly, if the pension is a public sector defined benefit scheme, its value is likely to have stayed the same during this time. Now, there are lots of reasons for that, but I think those are the helpful principles to bear in mind. As to whether a report from, say, February can be used now, again, I think it's going to depend on the type of pension and the importance of pensions to the case as a whole. Of course, the more significant the pensions, the more caution I'd advise in the circumstances.
Thank you, that's really helpful. So the second question is, do you have in mind a cut-off in the value of the pension where, say, you would advise a client to take a risk and go to a hearing without a pension report, and a cut-off where you say you would absolutely have to get a pension report? And what would you do if you had a client that really wanted to proceed and everything was in order, really, apart from either a pension report or an updating report was holding things up? Do you think you could proceed on that basis?
Well, as ever, I think it's going to depend on the context of the case. My cut-off value would probably be a pension of around £100,000. That's the value the Pensions Advisory Group say below which it probably wouldn't be proportionate to get an expert pension sharing report. Having said that, as a caveat, it's really going to depend on the circumstances of the case. So if the other assets are, for example, only £50,000, then suddenly a pension of £100,000 becomes a lot more significant. If the client really wanted to proceed, then I think you'd have to make sure that you set out the risks of doing so clearly in an advice. The risks, of course, being that the pension fund they're receiving as part of the settlement may be worth much less than they think.
Thank you, Alex. That's really helpful. What would be your advice now to anyone putting an actuarial report into the first direction appointment directions now? Do you have any idea of the timescales of obtaining these reports? And do you have any other tips as to how we can get round the uncertainties of valuing pensions at the moment so that we don't hold up proceedings?
Yeah, well, I think timescales are really going to depend upon the expert's availability and the ability of pension schemes to provide the required information. and I'd expect some delay in reporting times in the current climate. But again, that's going to depend on the expert you're using and the timescales that they're going to be quoting to you. But as a general principle, I think we can expect some delay on the usual timescales. Now, in terms of how to get around the uncertainties, I think there are lots of ways to go about that. But one way would be to spread the risk. Rather than one party taking all of the defined contribution pension and the other party taking all of the defined benefit pension, instead splitting both could be a way of sharing the risk, even if that involves more implementation fees. The other option, of course, in terms of taking the necessary safeguards yourself as a practitioner, is just to go back to the expert and ask them to take account of the market fluctuations.
Thank you, Alex. That's really helpful. In the same scenario, is your answer different if I was looking at pension offsetting rather than pension sharing?
Offsetting is often seen as very convenient, and in my experience, clients don't have as much regard or as much value, perhaps, for pension assets they're going to see the value of in some years' time compared to what they can perhaps get out of a house by way of equity now. And I think if you're looking at pension offsetting, then the risk of one party being shortchanged is even greater. In the current climate, I'd have significant reservations about offsetting capital against the cash equivalent value of a defined contribution scheme, for example. In any event, all of the recent guidance seeks to steer us away from offsetting as an option because of all the difficulties in making accurate calculations.
The courts until quite recently had given very little guidance about how we should treat pensions in financial remedies. My feeling is that the courts are now more willing to use the whole pension rather than the non-matrimonial apportionment. What are the recent guidelines that have been handed down by the courts, and are those guidelines COVID resistant? Are there any recent pension decisions that have been handed out from the courts?
Well, I think your feeling as to the way that the courts are tending to deal with things now is right. And I think there are a couple of resources to mention as to how we get to the current position. The first is the Pensions Advisory Group report released last year, which is a pretty comprehensive guide to pension issues. Within that report, it strongly discourages offsetting and sets out some of the reasons why in some detail. There's also the relatively recent case of W&H, a decision of His Honour Judge Hess, who looks specifically at that PAG guidance and how it might apply to the facts of that case. Now, anyone watching this video will be able to find a detailed case analysis elsewhere, but what I think is an interesting takeaway from that case is that while short marriages of young couples with small pensions might be suitable for offsetting, or even regarded as non-matrimonial property, once the marriage is longer or the parties are older and closer to retirement, the pensions will be seen as income-producing vehicles for retirement, and crucially, will be used to meet needs. Now, on that basis, even the proportion of the pension that was accrued prior to marriage will be up for grabs, on the basis that all available financial resources will be used to meet needs. So in summary, I think what we're seeing both from the Pensions Advisory Group report and from recent cases which include W&H, but there are other appellate cases which quote the report. I think what we're seeing there is a continued move away from offsetting, with the exception perhaps of short marriage, small money cases or small pension cases, and a move towards using the whole pension pot to meet income needs into retirement, particularly where the parties are nearing retirement age. And one interesting caveat or bit of context for that is that even when the pension pots are in excess of £1 million, courts are still finding that that is the sort of pension pot that actually is needed in order to meet parties' income needs into retirement. So it's not just the small money cases, or rather the very big money cases, that this happens with.
Thanks, Alex. That's really helpful. And if people want more information or further thoughts from you about this aspect, how can they get in contact with you?
Well, my contact details are available on our Chamber's website, but if it's a query about any cases and that anyone would like specific advice on, then I can be contacted through our clerking team within Chambers. Now, Deborah, you're going to come on to talk to us about arbitration, but just before you do, let me briefly introduce you to anyone who isn't familiar with you. Deborah, for all those watching, is a member of the Matrimonial Finance team in Chambers and also undertakes Talata and Schedule 1 applications. She's a member of the Chartered Institute of Arbitrators, IFLA, and the Family Law Bar Association. She has been a financial arbitrator since 2012 and also collaboratively trained since 2010. She also undertakes private FDRs. Deborah is appointed as a Deputy District Judge sitting on the Western Circuit. Now, Deborah, in times of court difficulties, with much talk about a court backlog and people struggling to get hearings listed, you're going to talk about the arbitration scheme, which of course deals with finance and children, but you're going to talk about the financial side of things. Let's treat it as though I know very little at all about arbitration. How is arbitration typically used within financial remedy proceedings? Is it used in my kind of cases or just reserved for those exclusive big money cases?
Thanks, Alex, and thanks for that introduction. I think that there are several factors that need to be considered when we're looking at arbitration as one of the options for resolving a case and considering whether arbitration is the right one for you. And I really feel that whether it's a big money case or not is not really one of those factors. So historically, absolutely, arbitration has been for big money cases. You just have to remember it has to be proportionate, and the arbitrator does come with a cost, whereas obviously having a final hearing in the court is there's no cost to the clients. So financial arbitration, I would say, is available in most cases. There are some exceptions. These include cases involving the liberty of a person, bankruptcy, insolvency, the status of someone or their relationship, and where a person or organisation is not a party to the arbitration. It's not an exhaustive list, but I do think it's quite rare. So I think that arbitration has typically been thought of as a quicker way to get a decision from the court than waiting for a court hearing. And I think that's very much so in these Covid-19 times. You can arbitrate almost anything. It may be helpful to arbitrate a first appointment. That fits in very well with then going on and having a private FDR. The parties will need to focus on what directions they want in the case, and whether they want it back into the court system or whether they want it to carry on within the private FDR arbitration system. All of these issues can be arbitrated. So the context of the arbitration is set out in the form, which is called an ARB1FS form. I'll probably refer to it as the form, and the parties sign that form. What is in that form really matters, and it defines the boundaries of the arbitration. So there are opportunities to reduce costs by stepping into arbitration, particularly when the assets are not extensive. So as I say, you can arbitrate almost anything. You can arbitrate, for example, the identity of an expert or whether one should be instructed, an application for interim periodical payments, or an application for a LASBO order. Really any issue you can't agree. I do find that chattels and house contents, if there's a dispute about that, are particularly well suited to arbitration. The courts aren't particularly interested in having a long-winded contest about contents, and you can take that out of the court system and into arbitration for that determination. Also periodical payments and in terms of term or quantum. The resolution of the arbitrator will be supported by the court, and it becomes a court order, and it's enforceable when that award is handed down.
Thanks, Deborah. That's really helpful. If arbitration is something that might work for my case, what practical steps might I take to pursue it?
The first thing to do is to check the nature of the dispute, that it's covered by arbitration, and to make sure that everyone agrees that arbitration is the right way forward. If there's disagreement by one of the parties, then that's the end of it. It stays within the court arena. You can also choose your arbitrator, or you can ask IFLA to nominate one for you. In lockdown, I've been asked quite a few times to give people some assistance in finding the right personality of an arbitrator, and I've been asked what various barristers will bring to a particular case. So that's always open to ask another barrister what they think about the potential arbitrator. So the parties are very much in control of the process. It can be done as a paper exercise, it can be done on the telephone or face-to-face meetings, or, as we all are at the moment, all geared up to do Zoom or remote video platforms for the entire arbitration. The main thing is that the parties must understand that even a consideration on the papers is going to be binding. They govern their procedure. The parties will either agree with the general procedure, or they can have an alternative procedure to their specific case.
And so putting ourselves in the shoes of someone who might be having a discussion with a client about the possibility of pursuing arbitration, why do you think it might be something that's of benefit to a client?
I can think of numerous advantages and actually very few disadvantages. It's quick to get a listing. Delays in the court can be sidestepped by using arbitration. Financial cases which are not perceived as urgent will be pushed back in the queue in the court, and therefore there is more room for arbitration than probably previously. The abilities of the parties to jointly select their arbitrator gives the feeling that there is a tribunal that is a bespoke fitting for their case, rather than just getting a random judge who may or may not be a specialist in financial remedies if you're outside the financial remedies court. The most straightforward of cases can be dealt with on the papers without an oral hearing. Obviously, that's binding. I do feel that the binding nature of arbitration is underpinned at the end by the process of getting a court order, which obviously is enforceable.
Thanks, Deborah. And we've heard quite a lot about private FDRs during this period of lockdown, and some of us, of course, will have experience of private FDRs. But in terms of the practicalities, how does arbitration work? What does it look like? Is it like a private FDR, or is it something very different?
It's not similar to a private FDR, although I understand why you would say that. You will, in an arbitration, get a binding decision from the arbitrator rather than an indication. And once the arbitration starts, the parties should not start or continue with their court proceedings simultaneously, so any current proceedings should be suspended. The parties can choose the arbitrator, as I say, or IFLA will appoint one for you. IFLA needs to know about the arbitration. On an initial approach to the arbitrator, you may be asking about fees, and what you'll like to get at that stage is a window of the likely cost of the arbitration, which the parties would then divide equally. If you disagree on the identity of the arbitrator, then IFLA can nominate. The parties need to sign and submit the ARB1 FS form to the IFLA administrator. They're at info@ifla.org.uk, and IFLA stands for the Institute of Family Law Arbitrators. Their website's really helpful, and it's very clear in terms of what you need to do in terms of submitting your form. And that the parties' details are set out and include the full details of their dispute on that form, which they have to sign. The arbitrator accepts the appointment and the arbitration commences, and once the arbitrator has been appointed, then he or she will contact the parties to agree the terms of the arbitration, including the nature of the dispute, a procedure to be adopted, and also the actual fee that's going to be incurred. A venue will also need to be considered. Most barristers use their own chambers, but obviously we're now looking at things done remotely as well. The final meeting can be agreed to suit everyone's availability and set down fairly swiftly. The procedure is then very similar to a court hearing in terms of evidence being heard and submissions made, and then the award is delivered usually about a week or so after the arbitration has had its hearing. The fees of the arbitrator must be settled before the determination is handed down, as well as any other costs such as the expert or the venue hire.
I see. And you mentioned that it takes place, of course, outside of the court arena. There may be a perception that because you're not in court and because you're dealing with an arbitrator rather than a judge, that the decision wouldn't be binding in the same way that a court ruling would. But that's not the case. Is that right?
So the starting point is that a published arbitration award is final and binding and enforceable as soon as it's handed down. Once an arbitrator has made a final award, they have discharged their duty and no longer have any power to make decisions in respect of matters decided. Generally, to challenge an award, you need to ask the arbitrator to correct the award or make an additional award, and obviously they're open to that consideration. But then if the party is still not happy with their reconsideration, then they must appeal within 28 days. So whilst the court's appeal jurisdiction cannot be ousted, the court recognises the parties' adoption of this process and should infer and be led by their agreement that the court's intervention on an appeal was intended to be limited to either substantive jurisdiction issues, such as the arbitrator strayed into areas that were outside of what had been agreed by the parties, serious irregularity, or a question of law. Thereafter, you've also got the family court options, such as the unforeseen supervening event in Barda and mistake, as in Mr Justice Mostyn's case of DB and DLJ. The right procedural approach is generally an application by the unhappy party to the family division of the High Court and not the family court under Part 62 of the CPR.
I see. For anyone that perhaps studied arbitration at law school but hasn't refreshed their learning in recent years, are there any recent developments in arbitration law or practice that we might need to be aware of?
The signals from the judiciary are very much in support of arbitration. Recently, the President has said that we should be exploring other avenues other than court hearings. Court hearings should be a last resort in these Covid-19 and lockdown times. And obviously, as we come out of them, there's going to be the backlog. When I qualified as an arbitrator in 2012, there was very little guidance from the court. But a couple of years later, there was a case called S&S in 2014. And the President, as he was then, gave an emphasis on that case of how immediately binding the nature of the award was, and he was very supportive of arbitration. A couple of years later, in 2016, the Family Court's interface with arbitration was published. And then more recently, there was a case called CM and CM, where Mr Justice Moore was faced with having to determine what was in a letter of instruction in relation to, I think, a pension expert. And he said that the courts were absolutely not there for that, and that it was something that would have been perfectly suited to arbitration. So very recently, there have been 3 decisions from Claire Ambrose, who has been sitting as a Deputy High Court judge. She's a commercial arbitrator, but they've arisen from where one party is not wanted to be bound by the arbitration result. So 2 were in 2019. The first is BC and BG. And this was a challenge under Section 68, and that's only likely to succeed in an extremely limited case. The unhappy litigant would have had to have proved that where the tribunal had gone so wrong in its conduct of the arbitration, then justice called out for it to be corrected, and the judge said that wasn't the situation in that case. Another case in 2019 was H&W, and this was an important decision which highlighted the limits absent agreement by the parties under Section 57 to an arbitrator's powers to revisit a final award once it had been formally handed down. And then bringing us up to date with a case called R&K, this was a challenge to an arbitration award. The former husband had sought for the arbitration award to be set aside, and Claire Ambrose found that the various criticisms of the arbitrator were unfounded, and the points raised were inappropriate attempts just to reopen the facts. So she declined permission to appeal, and she was satisfied that the award was not wrong. She said it reflected a fair allocation of assets and was firmly within the range of right outcomes, and she approved the award that was handed down.
I see. So help us then, if we're attending an arbitration, let's say I'm going to be representing a client at an arbitration, what do I need to be aware of to make sure that I secure the best result for my client?
The arbitral award has an immediate and binding effect between the parties, even if it might not bind third parties, and thus it's enforceable even before the court order is made. So really, you need to understand how the arbitration works, because your client will have lots of questions about it. And you also need to warn your client that they will be giving evidence and you will be making submissions in the normal way as if it was a court hearing.
So just tell us about that advocacy. How is that different in terms of the intimacy of the environment?
Yes, I think it is different to a court hearing. There's bound to be less formality as you're not physically in a courtroom. This can lead to a more interactive approach by the arbitrator and by you as counsel. There's also potential for there to be a more bespoke hearing, as you can limit what the arbitrator is making a decision on, and therefore your advocacy is also bespoke and controlled. You are looking at the remit of that ARB1 form rather than all of the issues that might come into a judge's perception. You can also be certain that the arbitrator has had time to read the papers and will be fully on top of your case.
And we're all familiar with the costs positions within financial remedy proceedings, but what's the cost position for arbitration?
There are two aspects to the question on costs: the costs of arbitration and the costs orders or arrangements between the parties. So there's the arbitrator's fee and the expenses. The arbitrator and the parties will need to agree that fee at the beginning of the arbitration, and the usual arrangement is that arbitration fee is borne equally between the parties. Obviously, if there's an expert's report or a venue fee, they are usually borne equally. There's then the parties' legal costs. These are the costs that have incurred by each party engaging their lawyers in the presentation at arbitration, and they usually bear their own costs, so very similar to a financial remedy court hearing. Obviously, if there's then an application to revisit the award or to an appeal, then costs would follow the event.
Thank you, Deborah. Moving on then to how arbitration fits within financial remedy proceedings. Is it necessary for there to be a stay of the financial remedy proceedings in order to allow time for arbitration, or does it fit within the existing timetable?
Yes, I would say at the outset you need to decide what you're arbitrating for. You can be flexible about it, but you do need to be clear about the boundaries. So we can't agree an expert, we can't agree the questions put to an expert, we can't agree interim maintenance. All of those things can go to arbitration, but you just need to be really clear. It's quicker and more effective, I would say, to have those issues arbitrated and then than to wait for a court hearing. But what you might want to do is to look at that as, say, the first directions appointment or the interlocutory stage, and then go on to a private FDR or a court-led FDR, whatever you want. So you just need to be really clear and think about how you want the case to evolve. You will have a good idea at where the case is going to settle, so it may be that arbitration at an early stage is a good idea. I've certainly done cases where one of the issues has been unblocked by arbitration, and then matters have gone on to resolve themselves.
Deborah, thank you. You're an arbitrator yourself. You advise on arbitrations and also represent clients at arbitrations. If anyone watching this wants to contact you to find out more, how should they do so?
So you can find out more about arbitration either by emailing me on the Albion Chambers website, which has got my email address, and any questions I can answer either in relation to presentation I've just made or about other barristers or solicitors as arbitrators, I'd be happy to help.